can see, we're going to be filming this, and it will be on the internet and offered later.
How long will you keep it on the net?
Do not know yet. Depends what the demand is.
Oh, okay. And will it only be available on the net to AOA members?
Okay, we are going to get started now. The cameras are rolling. And again, I want to remind each one of you that are here that this will be shown on the internet. And so if you do not want your likeness put on the internet, you'll want to sit off in a corner. My name is Dan Fowler. I'm president and one of the rulers of the American Socialist Control Housing Party. Our members and rulers have a great and long sought after accomplishment that I'm going to announce today. 1482. We finally got it passed. We have control of all the owners in the whole state of California. It's called the Tenant Protection Act of 2019. Now, some other people are calling it the Tenant Welfare Act, which we would argue with. This no state law has taken over control of all housing in the state. Can you imagine the accomplishment that we've been able to make? You'll not believe how giddy all the tenants and the politicians are today. They are out, and we are out celebrating this great accomplishment that's taken place. We finally put the final nail in the head of the coffin, and we've captured all of the apartment owners in the state and put them in our vice. And we're just getting started, folks. You haven't seen anything yet for what's going to happen. And we've taken over the old capitalist system that once governed housing. This old system was working before we were able to get all the laws passed and the construction laws to slow that down. The rent, boy, did we get rent control. We did a real good job in Los Angeles, West Hollywood, Santa Monica, San Francisco, Berkeley, and Oakland. We really did a good job there, but we didn't capture everybody. And so now we've been able to do that. They're in the vice, and all we have to do is keep screwing it down and keep going to the politicians and yelling for more and more, what do they call it? It's tenant welfare. More and more welfare for us. But now we have them in there, and we're ready to go with it and get things done and get this rent down to zero. Can you imagine the celebration that we'll have? Folks, that's what's going on today. My name is Dan Fowler. I'm president of the Apartment Owners Association of California. We're one of the largest individually organized groups of apartment owners, dues-paying apartment owners in the state. We have a magazine that goes to more apartment owners monthly than any other publication in the United States that I'm aware of. If you know of another publication, please send me a copy. We'd like to contact them and work together with them. It's a sad day, isn't it, when they pass this kind of rent control. I was talking to an owner a couple days ago, and the owner was telling me how wonderful her tenants were. There have been some recommendations that we raise the rent or that we evict some of these people so that we can get a fair price for our property that we've all sacrificed and worked so hard to get. She was telling me how nice they are. I said, are they really nice? There's a percent that really are. But if the politician were to come to your renter and say, if you'll vote for me, I'll get your rent cut in half, would they vote for him?
Oh, yeah.
They're just as guilty as the politician who passes the law. Just as guilty. So you have a group of tenants, not all your tenants, not all of them, but you have a group of tenants out there that are after your property. And they're doing a darn good job of it. And this bill kind of backs up what they've been able to do. I was talking to my son, Jeff, this morning, and I said, hey, this is just like being back in China, isn't it? He had spent quite a few years in and out of that country. And he says, they don't have rent control in China. They don't have rent control? We're worse than a communist nation? Our politicians have passed a law that way? Wow. I don't know what to say about it. That we're worse than that communist country there. We have some bills coming up. I want to tell you about those bills. Number one, the AIDS Foundation is again collecting signatures to put a ballot initiative on the ballot for 2020 to make it statewide worse than what the statewide that you're going to hear about today. And they're going to put that on the ballot and try to get that passed. The tenants are going to be working for it. Number two thing being on the ballot is to Prop 13. They're going after your property taxes. The politicians want more of your money too. It's not just the tenants that want your money. The politicians want to get more of your money. And so Prop 13 is going to be attacked on the ballot. Now that's going to be only for commercial property. So many of you say, oh, I'm glad they're not going to tax my apartment. And that's exactly why they're going to do it. Because you sit back and say, oh, it's not me, so I don't have to do anything about it. And there's some well-known stories about other countries where people did that and where certain groups were really crucified as a result of the other people sitting back, and eventually those people got crucified also. And they got torn up and put in camps and the whole bit because they sat back. And I want to encourage each of you here today, don't sit back, get involved. Do you know that the majority of you didn't even donate $100 to fight Prop 10? You didn't even, oh, well, I'll let somebody else do it. You kept the money in your pocket. Folks, I want to encourage every one of you and challenge you to donate to the AOA Political Action Committee at least $100 a year plus $10 a unit. It's your obligation to stop these guys from taking more and more of our property and taking that vice and just screwing it down tighter and tighter. Their eventual goal, now I won't be here when that happens, but their eventual goal for your kids or your grandkids is to take that property away from you and to have the state own it. That's the long-term goal of the type of people who think this way. And if they think this way, then that's the way they think. They're not going to be changing at all. Our speaker today, our next speaker coming up today, is a well-known eviction attorney who's in the newspaper today, in fact, about his advice. He's going to be giving you that advice today. He's a monthly contributor to the AOA magazine. He has a legal question and answer session that'll keep you up to date on the laws and how it changes. And changes are already taking effect right now being written up for those of you who have property in Los Angeles City, for some of you who have property in Los Angeles City. And we're asking you to join that magazine. Alone is worth the $79 a year of membership that you pay AOA. Also, you'll want to use the tenant screening that we have. It's the best tenant screening that you'll be able to find. One of the best, certainly. Also, sadly, some of you today are going to make a decision to sell your building and get out of this market. I'm not going to ask you to put your hands up, but some of you are going to make that decision. If you do make the decision, you want to call your association office first. In the brokerage division, we can give you an evaluation of your building and let you know what it's worth so that you'll know what to go on the market with your building if you decide to do that. I know this last couple of years I've built buildings. I provide housing, built close to 50 units. It wasn't in California, however. It was out of state. And that's what these tenants' welfare laws do to owners who want to provide more housing and provide it and put it out there for people to rent. Our speaker is also has a radio program. In addition to his column, he co-hosts the Landlord Radio podcast show. And today he's going to be educating us on what this tenant welfare program is all about, what it does to you, and what he would do for some of you to be able to find a loophole and get out of this building. It's a real pleasure and it's a real privilege for me to introduce to you, let's give him a big hand, Mr. Dennis Block. Dennis, thank you for being with us today.
Thank you. What a great message Dan tells. You didn't think he was serious when he was talking up 1482, did you? In any event, yes, my name is Dennis Block. 42 years ago, I started a law practice. It has now grown to 19 attorneys. 19 attorneys. I am so old, ladies and gentlemen, that 2 of those 19 attorneys are my children. They were battling in court, at least one was battling in court today. And I know the burning question that everybody has when they see me speak, knowing that this is my 42nd year in practice. And of course, the burning question is, how the hell do I look so good? How's that possible, right? But the truth is, I wake up at 3 every morning. I am at the gym at 3:30. I roll into the office at about 5:15. That's even earlier than Dan rolls into the office. Am I right? And I actually start taking phone calls. So everybody here, I'm going to give you the secret. If you want to just talk to me and not have to wait even one moment, what you're going to do, and this is a secret just for the people in this room, is that you call my phone number, which is on our brochure, and as soon as the recording comes on, you hit my extension 101, you're going to get me immediately, just like that, with one small proviso. You can only use that extension between the hours of 6 to 8 a.m. 6 to 8 a.m. and only for the people in this room. And as you sit here, I am taking a mental note of everyone's face. And I'll also be listening to your voices to know that you are here today. So between the hours of 6 to 8, after 8, you got to wait till 9 and go to the switchboard. I'm there all day, but of course, if you call during the day, you might get to talk to me or some of the other attorneys. People know that as a benefit of the Apartment Owners Association, the premier apartment owners association in all of the United States, that as a member you can call our office. There is no charge. You'll get to talk to an attorney. If you call early, you'll get to talk to me. And I'm sure anybody in this room called me and got me on the phone. Or one of my associates, so please feel free to call the office. Again, you don't have to be a client. Anybody can call as long as you're a member of the apartment associations. If you do go to our website, you'll see all of our video podcasts that I have. You'll see our legal issues on the law. So please make yourself available to that. But we've got a problem as we start this. And for the last couple of years, me and Dan, we were running around the state giving lectures to defeat Proposition 10. Because by defeating Proposition 10, we weren't going to have rent control. And we all worked hard. Maybe you didn't give as much money to the political PAC that you should have, but we did enough. And we actually defeated Proposition 10. In fact, not only defeated, it was defeated by 2/3 of the voters. 2/3. Can you imagine? So what the hell happened? Why all of a sudden now are we faced with statewide rent control? Did the legislatures not know what the voters wanted? Did they not care? Certainly Newsom didn't care. But that's what we're stuck with now. We're stuck with statewide rent control. And as Dan correctly puts it, it really should be called tenant welfare, because that's what it is. It's tenant welfare. But let's think about welfare. In a social welfare situation, what you have is somebody with a need, a cancer, lost their husband, too many kids, tough times. Can happen to anybody. There has to be some social net to protect these people. And they have to demonstrate a need. And then they get compensated. They get help. And the help comes from all of us through our tax dollars. But when we're talking about tenant welfare, do you have to demonstrate a need to get welfare? No. Can you be driving a $100,000 Mercedes-Benz and still be in a rent-controlled apartment?
Yes.
Of course you can. You don't have to demonstrate a need. We're going to hold all questions to the end, please.
Inject Botox.
Okay. So it doesn't, in fact, you know what? I have a building in Studio City. My rents are really good except for one tenant. He's an older man. I bought the building with him in it. He's paying me $982. $982 for a one-bedroom apartment in Studio City. I just rented a unit that I did renovate, and I'm getting $1,950 for the same configuration. Yes, it's renovated, but it's like about $1,000 more per month, right? Now, this guy actually needs help. It's an older man, and I know this would be devastating for him to pay market rent. But where is it that me personally I'm giving him $1,000 a month? me personally, because of our legislators, okay? And this is what we voted against, but it doesn't make a difference. So when you have a situation with rent control, tenant welfare, you don't have to demonstrate a need, and it's paid for by one guy. One person is paying, just like all of our buildings where we could raise the rent. So this is the scourge that we have found ourselves in, based on the fact of this AB Assembly Bill 1482 passing. So let's go over it, and let's talk about all the doom and gloom. And then I'm going to tell you ways to get around it. And that's the fun part. Because we always have to have a way around it, and that's what we're going to do. First of all, as we do that, the main part is that this state law does not come into play if you're already under rent control. If you're already under rent control, you don't have to worry about knowing about the state AB 1482, okay, or Civil Code 1162.2. You don't have to worry about that. So if you're under West Hollywood rent control, like I have many of my buildings, if you're in Los Angeles under rent control, if you're under Santa Monica under rent control, or even Beverly Hills, you don't have to worry about it. New cities that started with rent control are also Glendale, Culver City, and the big one is the unincorporated areas of LA County. So if your building was located like in East LA, it said Los Angeles, but really it wasn't part of the city of Los Angeles, your building is now under rent control based on the county supervisors passing rent control for all those. So another 175,000 units came on board just by that act of the county supervisors. And trust me, they are quite to the left. But if you're in that jurisdiction with your building, then you are not concerned with the statewide rent control. You don't have to be concerned at all, okay? But let's take, as some people were asking me before we even started, well, I've got a building in Los Angeles City, it's multiple units, but you know what? I bought that building, and I bought that building because it was built in 1984. 1984. So I'm exempt. So, therefore, I'm not part of the city of Los Angeles, and of course, I wouldn't be part of the statewide. So you're still saved, correct? Correct? No, of course not. Never follow my lead, always go the other way. So if your building is not under rent control, magically now, it will be under rent control. It's insidious. So where you thought you were protected by building a building in the year 1990, and you were free to raise the rents as much as you could, now you are under the statewide rent control. So be careful about that when you're thinking about doing some rent raises or just evicting somebody without cause. So if you are in rent control, but your building wasn't subject to rent control, you're going to be subject to the state law. Okay? Let's move on. If you're under the rent control ordinance for the state, that state bill, they're going to give you a rent increase. So what's the rent increase?
5.
Once a year, you're entitled to a 5% rent increase plus the CPI. I don't know how many questions I've got in my office about what the hell is a CPI and what is it for this particular year. Well, let me tell you. This particular year for the LA area or the Orange County area or around Long Beach is 3.3%. 3.3%. So the state is giving you a total of an 8.3% rent increase that you can do, okay, once per year. Actually, you can do it twice per year, but it can't exceed 8.3%. 8.3%. Now, how do you, the CPI is going to change from year to year. So how do you do it? Well, just do a Google search. Consumer Price Index, Los Angeles, and do April of the year 2019, next year do April of the year 2020 each year, because it changes based on year to year. So this year, April of 2019, the increase was 3.3%. And that's how we're getting the rent increase of 8.3%, okay? Now, if you raise the rent, let's say you were in a new building in Los Angeles, which is now under rent control, and you raise the rent, or let's say you had a wonderful property in a civilized jurisdiction, at least it used to be a civilized jurisdiction-owned property like Burbank, which has no rent control. And after March 15th, you had a rent increase that kicked in. Let's say you did a 20% rent increase. If you did, that rent increase is legal, absolutely legal, until January 1st. On January 1st, that rent increase is going to be decreased to 8.3%. And whenever you raise that rent last, let's say it became effective as of April 1st, 2019, you did it 20%. Now you have to wait till January, you have to reduce it to 8.3%. You don't have to give any money back. Everybody says, do I have to give the money back? No, the rent increase is legal right now, it's just going to get reduced. But then in April of the year 2020, you'd be able to do a new rent increase of 5% plus whatever the CPI is for April of 2020. Everybody following that? Not too confusing?
April 2020, right?
It's right now you can charge 8.3%. Okay, but you're going to hold your questions, you're going to write them down, and I'm going to, at the end of this, I'm going to answer every single question that you have. Okay? Now, there are some exceptions where you're exempt from rent control, the state rent control. So what are those exemptions? And this is kind of insidious. Dan, I don't even think you know this one. If your building had a certificate of occupancy that has been issued within the last 15 years, well, let's see, it's 2019, and I'm pretty good with math, so that means, oh, if a certificate of occupancy was issued in the year 2004 or later, I'm not under rent control. But you know, they did something very curious in the statute. They didn't say a certificate of occupancy issued as of January 1st, 2004. They said a certificate of occupancy issued in the last 15 years. Oh, I don't know how you guys are interpreting that. But the way I'm interpreting that is, if your building was built in 2004, by next year you're under rent control. Because that's what it says. It says a certificate of occupancy that's been issued in the last 15 years. Well, in the year 2020, that's going to be more than 15 years for a property in 2004. So this is going to be just a revolving door where you're under rent control. No. Oh, now I am, depending on when your building was built. I can't imagine a developer wanting to build in California and get a return on their investment when even if you build a brand new building in the year 2019, after 15 years your building's now under rent control. Why would you want to build in this state? You'd have to be crazy. And they talk about a shortage of housing. Well, this is the reason why there's a shortage of housing. This is the exact reason why there is a shortage of housing. There's other reasons why there's a shortage of housing, and that is because it costs so much damn money to build a building with all the regulations and the permits and the delays that you're getting from building and safety. It's insanity. Somebody was saying on the news yesterday, just to build any project, you're taking $150,000 before you put the first shovel into the ground, and I believe that. So if you want to solve the housing crisis, okay, then what you want to do is get rid of rent control, allow builders to build, and get rid of the regulations. But of course, that's not what we have. They're blaming high rents on the homeless problem in LA. In fact, they blame me. Today in the paper, they're blaming me for the homeless problem. So it is insanity. You ask anybody who's on the street, they're on the street generally because they're either addicted, they have alcohol problems or mental illness problems. hardly anyone is on the street because of an issue that their rents got high and they couldn't move anyplace else. That's not why people are on the streets, and of course the politicians know it. And in fact, I am setting up a task force, and anybody in this room can join me. I am going to pitch a tent in front of the mayor's house. If anybody wants to come, I'll stay there for a couple of 3 days, and let's see how he likes it in his house. You know, I go to the Staples Center. In fact, I'm going tonight because I see every Laker game. And I use Waze, so I know how to get there in the shortest way. So they're taking me down crazy streets. And you see the homeless encampments on these streets, like, oh my God. And I'm seeing this one beautiful building on Windsor. It's a beautiful, relatively new building, built within the last 15 years. Gorgeous brick building. And they've got 8 tents in front of the building. So, who wants to sit there in a tent in front of the mayor's house, okay? Okay, I got one guy. Okay. But I think that would potentially solve the problem. Okay, so we know that we have this roaming issue of whether your building will or won't be under rent control depending on whether it's received a certificate of occupancy within the last 15 years. Insanity that that's the way they wrote the law. It's from the January of 2004. Okay. There are other things that are not under rent control. Single-family homes, condominiums, and townhomes. Single-family homes, condominiums, and townhomes. Those are not under rent control. So you can take a deep breath that regardless of what statute or jurisdiction you're in, from Santa Monica on down, you're not under rent limitations. You might be under rent control where you have to have good cause to evict, but you're not under rent limitations of any kind. So, but they have an exception. Really? Yeah, they have an exception. If your single-family home or townhouse or a condominium is owned by a corporation or a REIT, that's a real estate investment trust, then you're now subject to rent control. So if it's owned by a corporation or a real estate investment trust, that's not like a living trust, okay? Then you're going to be under rent control. So people say, but gee, I have that condo in a LLC, limited liability company. I have the house in an LLC. Am I saved? And the answer is yes, unless the managing member is a corporation, which you can have crazy ways of starting entities. So if, in fact, the limited liability company's member, you're a member of the limited liability, is a corporation, then in that situation you are now under rent control. So word to the wise, don't own it in a corporation or in a REIT, that's for sure, okay? So what about, again, I don't want to get away from the point that I'm just talking about those properties that are not under a local rent control jurisdiction. So again, I got property only in Los Angeles and they're all under rent control. You can walk out right now. It's okay, because it doesn't affect you. It's only going to affect you if my property wasn't under rent control, but come January 1st, it will be under rent control. So in that situation, if you have a duplex, is that under rent control? Yes? No? Yes. And the answer is yes and no. That's the reason why lawyers are so tricky. They can answer a question and go opposite sides. But let me tell you what the specifics are. And that is, if it's an owner-occupied duplex, primary residence I might add, then the other person is not under rent control. So if you have that property, that duplex, and you live on one side, and you have a tenant in the other, you can raise his rent as much as you want, you can get rid of him, you can do whatever you want with that individual. So, I know what you're thinking. I'll get rid of one tenant, I buy him this duplex. And I know in Los Angeles, for example, but in other jurisdictions, there's a tenant there, I'll get rid of that tenant, I'll move in, and now this other tenant was only paying $642 for that Ocean View apartment in Venice. Now, owner occupied. Now, I can raise his rent, right? No. You had to have been living there when you rented to the other guy. You get that? You had to have been living there when the other tenancy was formed. So you just can't move in. That's not going to help you. Okay? So if you're in an owner-occupied duplex, you are not subject to this law. Now, it's not coming up soon, but it will be coming up. If you rent out non-rent controlled property for the state of California, you're going to have a special paragraph in your rental agreement come July 1st, 2020. The Apartment Owners Association, which keeps up with all their forms, will be certainly putting that into their lease agreements. If you don't have it in their lease agreements, then somebody can make the argument that you're now under rent control, because that's a requirement. But it's only a requirement as of July 1st, 2020. It is not a requirement for existing tenancies. Okay, but you might as well get used to doing it, so come January 1st, even though it's July, put it in all your rental agreements, this wonderful paragraph that will be contained in the Apartment Owners Association lease. Okay, let's move on. Okay, if you're going to create rent control, you got to do something else. If that's what you want to do, then you know you got to do something else, and that is you have to institute good cause to evict. Because otherwise you just evict the person. So they're not stupid. So you're going to have a statute saying what you need to do to evict the tenant. Okay? However, you're only going to need good cause to evict if the tenant has been there longer than 1 year. If the tenant has been there longer than 1 year, then you do not have to worry about having good cause to evict. So everybody, when they rent out property now, when you're going to be renting out property that's going to be effective to the statewide rent control, everybody rents out property by 1 year leases. That's just the normal thing to do, correct? Not anymore. We're not going to do that. Either we're going to rent it out by month to month, or we're going to rent it out by a 6-month lease. 6-month lease. Because you see, if the tenant hasn't been there longer than 1 year, then you don't need cause to evict. And that's where we are. We will not need cause to evict if they've been there longer than 1 year. So, I don't know why it is when you rent out a unit, I don't care whether the person is crazy, the worst person on the planet, just a mess, never pays his rent on time, looks disheveled. But when they rent out the unit, why is it that they look great? They're so nice. Let me hold the door open for you. Let me get this for you. Oh, I don't mind that it's a little dusty. Everything looks beautiful. You seem like such a nice person, right? And you can't wait to rent out the place to this person. And as soon as the ink is dried on that lease, it's like a till of the Hun. What the hell happened? There's a crack in the wall plate? What? I saw a spider outside the window? What? There's an ant? I don't care about your aunt. I don't care about your uncles. What do you want from me? What's happening to you? You've changed your chameleon nature. So that's why you don't want to rent it out on a 1 year lease under this statewide rent control. Because if you rent it out under a 1 year lease, okay, then you're going to have good cause to evict. Hey, I've been there 1 year. It's 1 year and 1 day. Now you can't just throw me out. But you see, if you rent it out either by month to month or a 6-month lease, you get to see how this person is. It's kind of like a trial marriage. You know, you take the girl home, you see how she is. Did it work in the first 6 months? Did it? No? Then you're finished, okay? So do it for only 6 months, because then you can see their true colors. However, I think these people, if they're crazy, they probably can't keep together for a whole year. They can do it during the screening process, but they're probably going to show their true colors. So one of the things that you should do is never, if you're under statewide rent control, rent it out for a year. Rent it out month to month, or rent it out for 6 months, so that at the end of the 6 months, you know what? Me and you, we're not getting along. So here's a notice. So you're going to serve a 60-day notice, and then after that notice expires, you're going to do what? Call me. Why do you think I'm here? Why do you think my number's on the bottom of the paragraphs? We can't ask questions until the end, so please write down your questions. Okay? There's also, again, you're going to need to put in that special phrase in your rental agreement dealing with the fact that this is a non-rent controlled property. But for the ones that are, again, just a 6-month lease, so you'll be able to get rid of them if you don't like them, okay? And it's not just a matter of paying rent. A lot of it has to do with the attitude. Maybe these people will pay their rent on time, but you dislike them for other reasons, okay? All right, now, but if they've been there for a year, and by the way, there's another exception. If another tenant joins the tenancy within that first year, then you get 2 years, okay, before good cause jumps in, okay? So if I've rented to tenant A in the first year, and then around the 9th month, hey, can I bring in tenant B? You might want to say yes to that, because now the time is extended to 2 years before good cause creeps in, okay? So you'd be able to get rid of them without cause for the first 2 years, based on the way this statute is working. Let's move on. Okay, reasons to evict. Okay, I'm stuck with rent control. It's already January 1st, 2020. Look at all these rent control tenants that I have here. What am I going to do to get rid of them? Well, there are a bunch of reasons. First one is non-payment of rent. Well, that's true in any jurisdiction. If the tenant doesn't pay the rent, serve him with a 3-day notice. The 3 days comes and goes. If he moves, that's great. If he pays, that's great. But if he doesn't, then obviously you'll call my office and we'll start an eviction for you. If we do evict a tenant, obviously you're not subject to rent limitations for that tenant coming in. What other reasons can you evict under the new state statute? And that would be a breach under the rental agreement. Let's pretend that the rental agreement says no pets, and he brings in a small Shetland pony. In that situation, you would be able to serve a notice to perform or quit. And again, all these forms are on the association's website, free to you as members of this wonderful and prestigious organization. Serve that 3-day notice, and if in fact they don't comply within the 3 days, then you got them. Now, what if they do an alteration? That would also be, the rental agreement states no alterations of the premises without the landlord's written consent. That's in every rental agreement. I just did one of those cases today. The guy mounted security cameras on the exterior of the property. You know, it's a multi-unit. He puts his own cameras up. So we are serving a notice to perform or quit to remove those cameras. Sometimes they put up those pesky little satellite dishes. It's okay for a satellite dish to be on your own patio or shoot it out your own window, but you can't put it on the rooftop and you can't put it on the exterior of the building unless they get your written permission per your rental agreement. So that would be another way to evict. A lot of times they'll bring in extra people. They bring in extra people again. It would be a notice to perform or quit. So that's the breach of the rental agreement. So I'll get this client. They say to me, Dennis, I'm dying under rent control. I know if I evict a tenant, I'll be able to raise the rent to market level. And he's doing something tremendously wrong. I go, what is he doing? He goes, he's got an extra person there. I go, great. Do you have a rental agreement? Yeah. And who does it say? He says, only one person. He's got 2 people. I go, perfect. Let's start the case. And then every client says the same thing to me. How am I going to prove it? I go, what? How am I going to prove it? I go, let me ask you a question. You're standing on a corner minding your own business. And a car goes through a red light and smashes into another car. You saw the whole thing. Person runs up to you and says, hey, did you see what happened? You go, yeah, the guy went through a red light. Does somebody walk up to you and say, how are you going to prove it? No, you have eyes. So you don't need cameras, though it's not bad. Just the fact that, hey, I know what this guy looks like. He's there every day. I see him coming and going. I see him in the morning leaving. I see him coming home at night. I know he drives a yellow Camaro and it's parked. You know, everybody here, you want to know something? Everybody's here, their car's right outside, right? So wherever you are, I know your car is there, unless you're taking it in for service. My car's right outside. So that's another way to determine that someone is actually living there, correct? So that is a wonderful way to evict, either under LA Rent Control Ordinance or West Hollywood or Santa Monica or under the new state. So a breach of the rental agreement. Another thing that you can evict for under the state statute, obviously, it would make sense if they're committing nuisance, waste. You know what waste is? Waste is like when you're chopping down the tree in front because you didn't like it, or you're just knocking holes into the wall. That would be considered waste. Criminal activity, like, I don't know, you had a small methamphetamine lab in the living room. You know, fun stuff that these tenants do. Or using the premises for an unlawful purpose. That's the guys who's making his daily tamales and tacos and selling it on the street, and the whole building smells like grease, has grease on the floors, and infested with cockroaches. So we've seen that situation. So if they are creating a nuisance, for example, then the state, thank you state, you're giving me a reason to evict for a nuisance. And let's pretend the nuisance is that the guy's having parties every weekend, yelling, screaming, loud music, won't turn it down, police being summoned to the premises, urinating out the windows. I don't know what these people are doing. But we know one thing, it's bothering other tenants. And you're getting call after call, day after day. It's time to call Dennis Block. So you're going to call me up and you're going to tell me the story. And I go, great, we got a great case. Let me tell you what the fees are. I said, but before we start, I'm going to need to have, the other tenants come to court to testify. Well, what? They're not going to want to come to court. What do you mean? They've been complaining to you. Everything, right? Nope. They're not going to want to come to court. They said, I'm not coming to court. The guy will key my car. Do I want that? You know what I'm going to do? I'm going to move. Because I don't need to deal with this idiot. So what does that mean? That means the good guys leave and the bad guys stay, right? So that's the problem when you create these good cause laws, okay? Now again, at least with the state, you get a 1 year to see if they're doing good or not. But if they're already going to be under, they're already existing tenants, you're somewhat stuck with them at this point. So how do you deal with that situation? Well, hopefully you can get some people to come to court and your manager. And then what you're going to do is you're going to do a little trick. As you know, lawyers are tricky. That's why we're lawyers. They taught us that in the first year, you have to be tricky. So what are we going to do? Say, listen, I don't need you to come to court, Mr. Tenant. I know he's bothering you, but this is what I want you to do. Just write a letter. That's it. You won't have to come to court. You won't have to look the guy in the face. I just want a letter. If you want, we can even do a petition. That'll be fine with me. All right? Just sign the petition, sign this. And then they're going to say, yeah. And then you're going to call me up. I got it. I got 4 letters, Dennis. That's great. I'm so happy. So can we start the eviction? Well, I can't use letters. Why can't you use letters? Because you see, a letter is improper evidence. It's called hearsay. You have to have the ability to confront your accusers, right? So why the hell do I want them to have a letter then? Very simple. Remember that tricky lawyer part? I subpoena them to court. Now they gotta come because they're under subpoena, or I'd issue a bench warrant. And then they come to court, then I put them on the stand, I take the letter, I put it in front of them, and I said, did you write this letter? Yeah? Good, you're done. Get out. So now I have the person there, and they have to correspond to what they said in their letter. So now we have grounds. A lot of times, though, it's not as doom and gloom as we think. We can get other tenants will be willing to come to court, but sometimes it is difficult. But that's what happens when you have good cause, is that your building can kind of get away from you, and you really got to step on this quickly. So nuisance behavior. Other crazy ones are Failure to sign a renewal of a lease after the current lease expires. I don't even know what that means, but they have that one in Los Angeles too. What that means is if a person's on a 6-month lease or a 1-year lease and the lease expires, you actually have the right to go over to that tenant, hand them a new lease with the same terms and conditions except for the rent increase, and say sign it. If they refuse to sign it, then in that situation, you could actually evict. That's true under Los Angeles and West Hollywood. And under the new law, that one rarely gets used. You can't take rent for the 13th month if it was a 1-year lease. So you send them the lease, 12 months are over, don't take rent for the 13th month unless he signs the rental agreement. If he doesn't, then we have grounds for eviction. Or if they're assigning or subleasing, the old Airbnb. You know, Los Angeles City started a home sharing ordinance, and the home sharing ordinance cannot be used in rent-controlled apartments, can only be used in single-family homes or those properties that are not subject to rent control. And the person who's doing the host, they call it, has to be there for at least half the year. So we have a situation where my son is in Tarzan at his house, and next door they have these parties going on every night, making everybody miserable with these Airbnb people because, hey, they're on vacation and they're in this big house and they want to party it up. So they have to see the nude people in the jacuzzi. I said, son, what's the problem with that? He said, well, it's not nice for my kids. So anyway, in Los Angeles, if you do have an Airbnb situation with a tenant, that is grounds for eviction under the new law. And that deals with assigning or subletting. Failure to allow access to a unit, that always happens. That happens in LA too. They claim that things are wrong with the premises, and then of course, they won't let you in to fix it because they're trying to make a case for eviction that you're not doing what you're supposed to be doing. But these are the grounds for eviction. Also, if the tenant fails to vacate after signing an agreement, you could do a voluntary vacate agreement. Hey, I'll give you $5,000 if you move. This is under the state. And if you take the money and sign the agreement, I don't know, call me silly, you got to move. That's under the state. So if you do have situations where you're stuck with this state rent control and your rents are really low and there's no hope in sight and you're not happy with an 8.3% rent increase, then you can do a voluntary vacate agreement. We do those in the Los Angeles area, Los Angeles City and Santa Monica and all the others. But in the state, now the difference between, believe it or not, the state rent control versus the city of Los Angeles rent control is if I have a tenant that I want to get out and I have no way of getting them out. I mean, we're talking Mother Teresa here. Pays their rent on time, quiet as a church mouse, but the rent is really low. So I might offer that tenant in Los Angeles and now in the state an agreement. Hey, I got $15,000 right here, cash. Do you want to move? If they accept it, okay, and sign the agreement under the state, you'd be able to evict for signing that agreement of intent to vacate or not. But most people don't know that in the city of Los Angeles under rent control, if you have a tenant sign a voluntary vacate agreement, some people call it cash for keys, and the tenant doesn't move, can you evict in the city of Los Angeles? And the answer is no, you can't. Because there's 12 ways to evict under the LA City Rent Control Ordinance, and that's not one of them. So how do we do all those voluntary vacate agreements? Because I came up with an idea. And my idea was, this is in the city of Los Angeles. I have no way of evicting for, hey, you signed this agreement, you didn't leave. That's not a ground. A ground is not paying the rent, bringing in the Shetland pony, but that's not a ground that I signed this beautiful agreement, took the money. I took the $15,000 and I didn't move. Now in the state, of course, you can do it, but in the city you can't. So the way we do it in our voluntary vacate agreements is we call it a voluntary vacate agreement / rental agreement. And it becomes part of their rental agreement. And then in the terms of the rental agreement, it says that if you don't move when you're supposed to, number one, you got to give me the money back. If you don't give me the money back, you violated a term of your rental agreement, and now I can evict you, serve you with a 3-day notice to perform or quit, because it's part of your rental agreement that you got to give the money back. If you don't give it back within the 3 days, then I can evict you. If I didn't have that in there, if it wasn't part of a rental agreement, I could sue for the $15,000, like a breach of contract, but I couldn't evict. But then we put in one more poison pill, and that's because lawyers are tricky. So what's the other poison pill? In the middle of this agreement, it says that the attorney fee for writing this intricate agreement is $3,500. But you, Mr. Tenant, are not responsible for it. That's going to be paid for by the landlord. By the way, I don't charge $3,500 for the agreement. And then it states, but if you don't move out, then as a term of your rental agreement, you're going to have to compensate Block $3,500. So now we serve a 3-day notice for the $3,500 plus the return of the security, the return of the relocation money. And if they don't pay both, which they won't pay both, now I have grounds. Very rarely does a tenant take the money, sign the agreement, and then doesn't move. But when it does happen, under LA for a normal cash for keys agreement, you have no basis of evicting unless you have something clever and call it a rental agreement / voluntary vacate agreement. Okay, so we've gone through all the reasons to evict where the tenant has done something wrong, okay? Failure to allow access, not paying the rent, methamphetamine, all those fun stuffs. But there's others. And that is where it's no fault of the tenant that you want the tenant to move. And that is where you want to have a family member move in. You're allowed to evict a tenant to have a family member move in. The family member that needs to move in would be either yourself, spouse, domestic partner, children, grandchildren, parents, or grandparents. Notice I didn't say brother, sister, uncle, second cousin, twice removed, okay? So only those parties are allowed, which is, again, either yourself, your spouse, domestic partner, children, grandchildren, parents, or grandparents. Those are the ones. So if you have a unit that you want to vacate, then you can, under the new ordinance for the state, say, I want my person to move in. It's grandparents, parents or grandparents. And then you're allowed to ask that tenant to move. Now, you have to pay relocation. Well, what's the relocation? Well, everything that the state does is bad, but considering how bad Los Angeles rent control ordinance is, it's not bad at all. It's 1 month's rent. Okay, that's not bad. I mean, why should they take any money? I don't know. Last time I checked, I paid the down payment for this building. I paid the mortgage payments. I do the maintenance. I pay the real estate taxes. Why do I even have to serve you a notice? You go. It's my place. You're on a month-to-month. Get the hell out of my building. But no, we're going to have to do that. But at least if we want to have a family member move in, we have the right to do so. We have to serve a 60-day notice if they've been there longer than 1 year. And we're going to have to pay relocation. You're going to need to have this phrase again in your rental agreement. So there'll be certain phrases in your rental agreement which talks about the fact that, hey, we can ask you to move. Okay, and if you don't have this in your new rental agreements that are started after January of 2000 and, was it January? Yeah, no, it's July 1st, 2020. Then you're not going to be asked that tenant to move. These are for tenancies that started July 1st, 2020 or after. You have to have a special notation in your rental agreement that says, hey, if I want a family member to move in, okay, then in that case, I'm going to ask you to move and you're entitled to 1 month's rent. Now, you can give them the 1 month's rent by either paying it to them, or you can say on the last month it's a credit, you don't have to pay me. Those are your options, and that has to be contained in the notice that you serve, which way you're going to go, okay? You can also withdraw a unit from rental housing use. That means you're permanently withdrawing it. Usually that would be in a situation where you're going to be developing the property, you're going to be bulldozing the property, and you're going to put up those 8 units with the subterranean parking, okay? So you're going to knock down this duplex. In that situation, you have the right to do so. Again, you'd have to serve a 60-day notice for the state. At least that's the way I'm interpreting it, but it might change on us based on when the final things are interpreted by courts. And you're going to have to pay that relocation money. Again, the relocation money is 1 month's rent. Also, if you get a governmental order that you have to stop renting this unit, for example, that it's an illegal unit, then again, you can serve the tenant with a notice, and again, you're going to have to credit 1 month's rent or give them 1 month's rent to get out. Okay, so that's all the doom and gloom. It's a very sad state of economy. So what the hell can we do to get around it?
Call Dennis Block.
Call Dennis Block. Thank you so much. That's my dad over there. No, I'm just kidding. Okay, ways to survive. I am getting slammed in the LA Times because of the advice that I'm going to give you right the hell now. And I'm encouraging everybody to do it. And you can tell them that Dennis Block, that mean, grubby landlord. Now, first they called me the prominent landlord. Then they called me the rich landlord. And what else? I don't know what they've been calling me. But they've been slamming me in the Times. But the first thing is, everybody who has property that will become under rent control as of January 1st, I have now freed you. You are not a slave anymore. And because all you have to do, and we only have 15 more days, and that is we need to serve a 60-day notice to vacate on our tenants. So remember, our property is not under rent control. So let's take a look at Burbank. Burbank's not under rent control. And I've got a tenant there that's paying $642. And I was a nice person, and I never raised the rent. But now, because the persons were nice and I didn't care, and I'm happy, but I know what's going to happen in a few years. My kids are going to inherit this building, and then they're going to say, "What the hell did you do, Dad? You left me a building with $640 that doesn't even pay for the utilities. Are you out of your mind? How could you?" So now I'm starting to feel sorry for my children, who all they want is everything that I own. That's it. These grubby little kids. So they're there, and right now, wait a second, it's more than 60 days till January 1st, so I'll just raise the rent. I can raise the rent in Burbank, right? Right now I can. But as I told you, if you raise the rent, and it's legal, come January 1st, they're going to knock it back to only an 8.3% rent increase. So that doesn't help you. So what does help you? What helps you is to kick them out. Serve a 60-day notice. You can serve a 60-day notice. They'll have to be out prior to December 31st. They'll have to be out prior to December 31st. We've been serving these up like hotcakes. And do you have to feel guilty, like what the LA Times said about me? And the answer is no. Did we create this problem? No. Did our legislature create this problem? And the answer is, of course they did. They're the ones who did this to us, okay? So if you have a tenant that's in a non-rent controlled area that will become rent controlled, so if we're talking about Manhattan Beach, Redondo Beach, you name the city, okay? If it's not under rent control now, you can serve a 60-day notice. If you serve a 60-day notice, that tenant will have to move prior to January 1st. And then you can have market rent for the new tenant coming in. Or is that tenant going to be under rent control? The answer is yes. But at least your rents are at market level. Now, I have a lot of property in West Hollywood. They have abusive rent control there, right? I mean, they give you 0.5%. I think this year they actually gave us 3%. Wow. It's the first year. But I don't care. I'm getting $3,500 for a 2-bedroom apartment. My rents are as high as they can be. So I don't care. If your rents are at market value, you don't care. I mean, you care, but you don't care. So this is one thing you can do right now. Tell all your friends. Tell all your relations Tell all your investment buddies and tell yourself, right now, you got about 15 days to serve a notice to terminate, okay? Because as long as it's over it's going to expire prior to December 31st, then in that situation, you will be able to evict the tenant, and you'll be able to get a new tenant in there. So this is your lifeline right now. You heard it from me. Tell everybody. So then the city of Los Angeles got cute, and they specifically mentioned me at their city council. And they said, Block's telling everybody to evict everybody. That's right, because you guys started rent control. And now all of a sudden, the building that wasn't under rent control is. So we have to pass an emergency motion, which they're going to pass. And it's going to say that you can't throw them out in this interim period of time. So I did a tweet, and I said, what a bunch of grandstanding idiots. And why did I say that? So that they would audit me for my city tax. That's why I said it. Oh, no, they've already done that 3 times already. I got that down real good now. No, so they're doing that, and why did I say it's grandstanding? Because it's really not going to affect anybody. It would only affect those few landlords that have a building in the city of Los Angeles. I don't care about Redondo Beach, Manhattan Beach, or Lancaster or Ventura. It's only the people who have a building in the city of Los Angeles where your building was constructed after October 1978 and prior to February 1st, 1995. If it's within that range, then you're screwed. If they pass this, which they are going to pass, then my advice to you of serving a 60-day notice is not going to work. But any other city, okay, from Santa Paula to Orange County to any other place you can imagine, except for the city, and only between those 2 days. Those 2 dates, October 1st, 1978 to February 1st, 1995. Only those buildings built between then in the city of Los Angeles will be affected. So I don't think it makes much difference. And they're just grandstanding like they're trying to do something to stop Dennis Block. That's not going to happen. I can't be stopped because I get up before they get up, and you know I do. Okay, so that's the first thing. Tell everybody if you're in a situation where you have property in an apartment building in Lancaster, Palmdale, I don't care. Right now you have an option. Look, if you have nice tenants and you're happy with an 8.3% rent increase, I'm happy with that. That's fine. You know, my rents weren't that low. Then don't do anything. You don't have to evict somebody. But if you're going to catch the ire of your children with that $642 apartment, and then they're going to be yelling at you from the gravesite. Reminds me of a story of a woman and a daughter were walking through a cemetery, and they pass a gravestone, and it says, "Here lies an honest man and a great attorney." And the little daughter looks at the mother and says, "Did they bury 2 people in this grave?" That's how much they hate us, especially the city council. Okay. I already talked about the second way is make sure that you lease units for 6 months or month to month. So this way you can do a little taste testing of your tenant to make sure that they are nice. And if they're not, you have a window of opportunity to evict. The next thing that you can do is now this is again, you're under state rent control. We're not talking the city of Los Angeles or Beverly Hills or West Hollywood or Santa Monica. Look up. San Francisco and Oakland. You can do substantial renovation. If you're doing substantial renovation, you pay the tenant 1 month's rent, and then you can redo the unit. Now, they actually had a definition of substantial renovation, and it requires replacement or modification of any structural, electrical, plumbing, or mechanical systems. It's going to require that you have a building permit, and it's going to require that the work would necessitate at least 30 days worth of time. I don't know about you, but anytime I have to renovate a unit, I have to get a building permit, and if I didn't, I'd get one now, and make it substantial and make the project longer. So it's only 1 month's rent, plus you're probably going to do a bunch of work anyway, right? Because you want to get a bunch more money for the place. Because obviously, if the rent is very low, then you haven't done anything with the place. So they are giving you a crumb, and I mean a crumb, by allowing you to do substantial renovation. So that's another way around the state. So if you're caught with statewide rent control and your rents are really low and the tenant is acting nice, not violating the contract, and paying his damn rent on time, well, why shouldn't he? It's so damn low. Then in that situation, you can do substantial renovation, get yourself a contractor, comply with the law, and then you are free. Have a nice brand new unit, and you can raise the rent to market value. Next thing I'm recommending now, based on the fact that every jurisdiction will now have rent control, is rent out your parking separately from the agreement. So let's pretend you want to get $1,500 for the apartment. So rent the apartment for $1,475 and do a separate parking agreement. I have one in the packet here. I'm sure the association has one, which allows you to rent the parking separately. Well, why do you want to do that? Well, you're seeing parking is commercial. It's not residential. So if you're kind of stuck with this guy, you can always go up on the parking. I think I want $250 per month for parking. Or you could just take the parking away. Here's a 30-day notice, and I mean only a 30, even regardless of how long he's there, and do it. It just gives you some more ammunition, okay? You could even do a rental agreement that says, rental is $1,500, no parking. And now here, I want you to sign this month-to-month parking agreement where the amount of rent per month is $0. $0. So that's my rental agreement, or $1. As long as you have it separated, okay, now you are in control of the parking in your building, which means you can kind of control the tenant. Imagine him coming back from Costco with 400 pounds of groceries and stuff, and he's got to walk 2 miles. We're not playing fair here, because they don't play fair with us, okay? All right, so those are the things that I have determined that you should do with regard to the statewide rent control. I do want to touch on a couple of other items that are very important. In your rental agreement, and the AOA is the best rental agreement on the planet, make sure that you do have these terms in your rental agreement, or you should do a 30-day change of terms of tenancy, which you can get from my website. But again, if you use the AOA rental agreement, these are there. And that is that all repair requests must be in writing. All repair requests must be in writing. We like that because a lot of times tenants will, in an eviction lawsuit, claim that a lot of things are wrong with the premises. And they'll file an answer and they check off every box. You know, there's no hot and cold running water. There's no door locks. There's no heat. There's no stove. There's no stove? I gave him a stove. And then you send the answer, what the tenant filed with the court, to the client. The client goes out of his mind. What are you talking about? There was an oven door, you know? There was a stove. We had smoke detectors. There's hot and cold. He never told me anything. So we like to have it where we put repair requests in writing. So I have a way of checking this, and when the tenant goes to court, we can put the tenant on the stand saying, gee, all these things are wrong. You're supposed to send something in writing. Did you do it? No? Because my client is saying you never told him, and you're supposed to put it in writing, and did you? So repair requests in writing. You also want to make sure that you have a paragraph in your rental agreement that talks about renter's insurance. You're demanding that the tenant have renter's insurance. I don't care whether they have it or they don't. You just want them obligated to have it. And the reason for that is, if in fact there's a flood in the unit through no fault of the tenant, and I don't know why this happens, but every time there's a flood in a unit, there's always a $10,000 Persian rug that gets destroyed. I don't know why that is. It's almost like that same Persian rug goes from apartment to apartment. Hey, you got a damaged Persian rug? I need one immediately. And then, of course, the tenant's going to want to sue you for the damage. It's not his fault. Under the law, technically, you're not responsible, because you can only be responsible under the laws if you have a contract that says, I'm going to take care of your personal property in case of damage, and of course there isn't. Or if you're negligent, like you ran over somebody's foot in a traffic accident. That's negligence. But how are you negligent when a pipe breaks? You didn't know a pipe was going to break. You know how you know when your roof leaks? When it rains, right? Oh my God, my roof is leaking, right? So technically you're really not responsible for his personal property. But if you have in your rental agreement where the tenant has to have renter's insurance, it's going to specifically have a paragraph, as the association lease does, that says if anything happens to your personal property, I am indemnified that you can only seek compensation from your insurance company. So it just saves a lot of lawsuits back and forth from your tenants. But there's one more important reason why you want to have renter's insurance, because you want to have a term in that renter's insurance requirement in your rental agreement that says that if you're temporarily displaced, you have to take care of your own relocation expenses. So let's pretend this apartment is flooded. He's going to be out of the unit, right? Or let's pretend that you have to tent the building for termites. Oh my God. And you have to walk over to the tenant and say, hey, I'm sorry, but you got to get out. We're tenting the whole building. And the guy goes, well, okay, I'll leave, no problem. But you know, I need a place to stay. And if you're like my daughter, she's an attorney at the office, she doesn't stay at any place. She stays at the Ritz-Carlton. Maybe the Four Seasons, okay? And when she's out in this Four Seasons, she has no way of doing her laundry, so you have to now pay for dry cleaning. And my daughter likes to get massages at noon, so you're going to have to pay for the Ritz-Carlton massage at noon, right? But you see, in our rental agreement, what we're going to put is that if we're temporarily displaced, your renter's insurance policy has to cover all that. Your lodging, your food, your medical situations, your massages, we don't care, just as long as you don't do that. So you need to have that phrase in your rental agreement. You also need to have
Can you repeat that phrase again?
it's basically where you're stating that the tenant is required to maintain renter's insurance. The renter's insurance will cover losses to his personal property regardless of how it was damaged, and that if the tenant has to relocate, that his relocation expenses would be borne by that insurance policy. And someone called me just today and said, you know, where do I get insurance that will cover for temporary relocation? I didn't see that in any of the policies. My position is, I don't care. I just want it in that you have to have an insurance policy that covers that. So this way you can't come back and sue me. Also, you want to make sure that there's a limitation of attorney's fees in your rental agreement. Most rental agreements say that if you're the prevailing party in a lawsuit, then you get reasonable attorney's fees. That's a terrible position to have in a rental agreement. It's certainly not in the association rental agreement. You want to limit it to $500 because, God forbid, if you lose the case, these attorneys are going to state that on the other side that it costs $20,000, and you're going to be responsible for $20,000 in attorney's fees unless there's a limitation. If you win, you could get $20,000 too in the form of a piece of paper called a judgment. Doesn't necessarily mean you're going to collect, but against you guys, they're going to collect. So we want to make sure that your rental agreement does have that limitation on attorney's fees, and of course the association does have that. Last but not least, when you buy a building, if you have an existing tenant, there's a trick that tenants' attorneys are doing that is causing us to lose cases. So I'm warning everybody now. When you buy a building, you have to do a written change of ownership. And in that written change of ownership to your tenants, you have to tell the tenant who's the owner, a name of a person who to contact, a phone number of a person who to contact, an address where to contact, and it has to be a physical address. You can't do a P.O. box. You have to have a specific address where they can come and serve you with a notice, or they can come and serve you with a lawsuit. Now, I have a lot of clients, they say, but I don't want my tenants to know where I live. That you don't have to give them your address. You could give him your brother's address. You don't like him anyway, right? It's kind of a dead audience. You're supposed to laugh on that one, okay? So in any event, you want to make sure that you have an address and where rent is to be paid. Well, that makes sense. It could be a rent collection box on the property. It could be a bank with your account number. Give them the address of the bank within 5 miles of it, and you have to have a phone number. This is mandatory. We're losing cases because you buy a building 10 years ago. There was a tenant there 15 years ago. For 10 years, the guy came to your house, paid you to rent, knew your address, gave you Christmas presents, okay? And now, 15 years later, you serve a 3-day notice and he doesn't pay. They're using this saying, did you serve an owner's letter? No, but he's been coming to me for the last 10 years with my phone number. He knows my phone number, he's called me, he has my address, he's been 10 years. And the judges are interpreting this code, stating that if you didn't serve that letter, you cannot demand rent. So, if you have tenants right now where you bought the building and you didn't do a letter that has all of those criteria, do it now. You can just say, just updating my contact information if you don't want to embarrass yourself. Updated contact information, give them the same stuff. So this way you are in compliance with the law, okay? You can do email well, no, you can do, it has to be a physical address where they can contact you, okay? No, it has to be in writing. It has to be in writing. I want to leave you with one story before we take questions, and I will stay here until I have to go to the Laker game tonight. Because I have not one, but 2 Patron margaritas waiting for me at the bar. So here's the story, and the story deals with a landlord, a very philanthropic landlord who's walking on the beach. And as he's walking on the beach, he sees a bottle buried in the sand. Then he picks it up and he rubs it, and out comes a magic genie who's been trapped in this bottle for thousands and thousands of years. She is so happy. She says, I'm going to grant you one wish, and one wish only. Being a very philanthropic landlord, he says, okay, I wish for world peace. She looks at him and says, you know, there's about 6 billion people in the world. It's kind of a tall order. Maybe you could give me something else. He goes, okay, I wish for a cure for cancer. She looks at him and she says, you know, the human body is somewhat intricate, and this might be above my skill level. Give me one more. Whatever it is, I will take care of it. He goes, okay, I'm a landlord, and I want to do away with rent control. She looks at him and she says, let's go back to that world peace one. Anyway, thank you very much. If you got any questions, we're going to have Dan hold the mic here. You guys can come up. I hope you learned a lot about the statewide rent control and how to get around it. And if you see anything bad in the LA Times about me,
What you do, you
it's
form a
true.
line right over here. We'll take you as in line. If you want to get in line, and we'll answer all the questions. Step forward a little bit of the mic, you're right behind the mic, right there. There we go.
The question is, the 8.3%, is it fiscal 12 months, or when does it start? In cities such as Glendale, if we had 7%, so what do we do after that 1.3%?
Okay, Glendale has its own rent control, so we don't have to worry about the state law. But to answer for the state law, it's going to be as the 3.3 CPI deals with April of each year, the change as of April.
Can they establish a anniversary date? You might explain that.
Yeah, you want to establish, so if you, and I think I discussed this, if you raise the rent as of June 1st, 2019, then as of June 1st, 2020, you would be entitled, assuming the CPI doesn't change, to an 8.3% rent increase.
So for people in the city of Glendale, if we raise the rent at 7%, which that's what it is, to avoid the relocation, so what do we do then?
Well, in the city of Glendale, they actually have a pretty easy statute. It says you can raise the rent by 7% or more. But if you raise it more than 7%, then you have to offer the tenant relocation. The relocation is a complicated formula, which you almost have to call up the city of Glendale, but it's basically 2 months' rent plus $1,000.
We're not talking about the Glendale relocation thing. We're talking about complying with the state AB 1482. So if we did the 7%, and when do we do the anniversary for the AB 1482?
Okay, because you're missing the point. And the issue is, if you're under a local rent control statute, then the state law does not apply to you. Next question.
Yeah, we're gonna limit everybody to one question. If you have more than one, then go back to the end of the line. That way we'll get through everybody.
Hi, I have a few houses over at Santa Clarita and Valencia for rental, and I'm planning to set up a LLC and have property management because I'm getting too old. Would that become a subject to rent control?
And the
then?
answer is thankfully not. If your property is owned in the form of an LLC, it is not under rent control, with the exception would be if the managing member of the LLC is a corporation, which it's not going to be, then it would be subject to rent control. So right now you're golden. Set up your 3 houses in an LLC and pick an interesting name for your LLC.
Hey, Dennis, just to elaborate, when you say managing member, are you talking about?
You got to get in line to ask a question. Get in line.
So can I have somebody
You can certainly have somebody manage your unit.
manage? and-
Absolutely.
Okay.
Does this lady look like she's too old? Huh? No, nobody thinks you are.
For the single-family resident, just cause, do they apply or?
No, in single-family residence, it's not under rent control. You can just serve a 60-day notice to vacate.
Hi, I believe I heard something, obviously not in your seminar, but just in the ramblings, that there was going to be mandatory Section 8. Is that part of
Yes,
it?
that is state law now, that you can't reject an applicant merely because he's a Section 8 applicant. That you can't look at that as a negative source of income and say, no, I don't want a Section 8 applicant. This is a new state law that has just come on. However, that doesn't mean that you can't reject an applicant. If the person has bad credit, then that means you can reject them. But you just can't say, no, I don't take Section 8 applicants. Don't say that because you're going to get sued and you're going to have to hire an attorney. Okay? But you do have to allow at least an application process, and if in fact he meets your criteria and doesn't have bad credit. But in most situations, call me silly, these people don't have the greatest of credit. And you can certainly have criteria of rejecting an applicant based on bad credit.
Another way to do that, AOA gives with a tenant screening an A, B, C, D, and F grading. You can say my building accepts only the B rated, and you could do better screening that way.
In fact, I have that form, the A, B, C, D, F form, in the packet.
Okay, it's a good way to do it.
If you're going to serve a 60-day termination notice by certified mail, should you use a return request card?
I say not. Most people don't realize that unlike a 3-day notice to pay rent or quit or a 3-day notice to perform or quit, you can serve a 60-day notice by certified mail. There are 2 ways to send pieces by certified mail. One is regular certified mail, and one is return receipt. We get that little green card, which they always leave on the side of the envelope, and then they never return it. So I say just do it by certified mail. You can prove that it got there by going online and tracking it. And as long as you sent it by certified mail, whether they got it or not, the law doesn't really care. So certified mail.
And in general, is certified mail a good way to serve?
For a 60-day notice, yes. I mean, I recommend going out there and posting one on the door, mailing one. We use a process server. But it certainly is permissible. And in fact, I had a certain situation where we couldn't get to the door last week. So I said, you know what? Let's just send it by certified mail.
For the rollbacks, to rents of March 19th, March 15th of 2019, how will they check compliance? And does that apply only to existing tenants then, not if we rented to a new tenant, like say April 1st?
Great question. If you're renting to a new tenant, then whatever you rented it to him is fine. You're golden. There's no rollback because he's never had any rent other than what you rented him to. The other question was dealing with, I forgot already.
Compliance. Will they
compliance.
check compliance?
How are they going to check? So you know what? I raised the rent, right? Do they have now a statewide rent control board like they have in Los Angeles that is going to come out there and check? And the answer is no. So then how are they going to comply? It's real simple. So you raise the rent more than what you should have, okay? And now 10 years go by, and now you're eventually, this is like a ticking time bomb. 10 years go by, and now you're going to evict this person, okay? And he's going to want all that rent back because he's going to go to an attorney. So it's kind of like self-complying, where it's your tenant who's going to come after you. The state's not going to come after you, but the tenant's going to come after you. So never raise the rent more than what you should. Never round up. If it's, $2,499.99, don't go to $2,500. That will ruin your eviction case and force you to maybe give back a bunch of money.
Could all that extra rent also incur a penalty?
It doesn't incur a penalty under the state law, but again, it's like a ticking time bomb where you might have to give this money back in years. So it's not worth it. If in fact you're under the law, comply with the law, I got to give all the money back except for the up to 8.3%.
Come forward a little bit.
Okay. Okay.
Don't touch the mic.
California law allows the recreational use of pot. However, federal law does not. And I just learned that one of my tenants has a son who is smoking pot with some of his friends. So I sent my tenant an addendum that addresses criminal activity being a reason for breaching the rental agreement. However, she has not responded, and if she doesn't sign, would that be a legitimate reason to issue a 60-day notice to vacate?
Where is your property located?
Azusa.
Azusa. Is it a house or an apartment?
It's a house.
Single-family home?
There are 5 little houses on the property.
Okay.
And they're separate, have their own yards.
Yeah, so number one, you can't just issue a 60-day notice under the new rule, okay? So you're going to have good cause to evict. The fact that they're in compliance with the state law but not, quote, in compliance with the federal law, that is not going to be a ground. So anybody can recreationally smoke marijuana in this state if they want to. However, you're not allowed to smoke, cigarettes are legal, and you're not allowed to smoke them on an airplane. You're not allowed to smoke them in this building or in a restaurant. And you're not allowed to smoke because it's going to bother other tenants. So if other tenants are being bothered by that, it's not that I'm telling you anything about the law and you smoking, because what if he's smoking cigarettes? What difference does it make? It's all smoke is a carcinogen. So what you do is you want to send this tenant a letter saying, you're bothering, assuming they are, you're bothering other tenants and you're creating a nuisance. So I don't care where you smoke, just don't smoke in a place where you're not bothering other tenants.
Your good cause is a nuisance.
By new law, you recommended that effective January 1st, we get 6 months instead of first year. First of all, why not 9 months? And second of all, is it still for termination? Should we give them 60 days notice by new law or still 30 days before 1 year?
Okay, if the tenants live there longer than 1 year, you'd have to serve a 60, assuming you could. So the reason why I say 6 months, I don't want to get it close. If I do 90, if you rent it out, let's pretend on February 1st, 2020. I rent it out by a 6-month lease. If after that period of time I don't like them, I could issue a 30-day notice. If I do a 9 months, I've got a couple of months to swing. So I just think it's better to either do a month-to-month now or to do a 6-month lease. So I've got a few more months to decide.
Still 30 days.
It would be a 30-day notice because that tenant who moved in the year February 2020 is not been there longer than 1 year. Because once they're there for a year, you know what happens. You have to have good cause.
Thank you.
My question is about renter's insurance. I was in court yesterday and I was told that the judge is going to judge against me because the tenant, we had a flood and he was claiming $5,000. I went to mediation. She told me if you go in front of the judge, you're responsible. And so what do we do in a case like this?
Well, first of all, the judge didn't rule against you then. You did mediation, is that correct?
Yeah, but she told me that
Well, what she told you and what the judge would have done, who knows? But generally in small claims court, landlords always lose. And that's why you have the ability to file what they call an appeal, where you get to have a brand new case in front of a brand new judge. So, but again, you basically settled the case because somebody scared you. But you see, that's what mediators do. Mediators are not to be fair. Mediators, when you do mediation, if you've ever gone through it, and it's ugly, when you do mediation, you're telling your part, they're telling their part. And what the mediator does is he goes over to you in a closed room and he scares the hell out of you how you're going to lose. Then he goes over to the other person in the other closed room and he scares the hell out of them. Okay? And then eventually both people are scared and they finally settle the case. And if he settles the case, then he's done his job. He's mediated it. Okay? So I take for a grain of salt for mediation, and I usually like to stick to my guns when I know I'm right. So
what do we do when people don't carry renter's insurance?
you don't have to, then what you do is you defend yourself when they bring forth the eviction. When they bring forth a small claims court against you, defend yourself, go in front of a judge, tell the judge the law. Tell the judge, look, I went to the Dennis Block seminar, and I'm sure the judge will say, oh, I use them for all my evictions. And he says, yes, and he said, I'm not responsible. So,
But what do you do when the tenant refuses to take insurance?
but you don't care that the tenant refuses to take insurance. You only care that if he tries to sue you, that you have a defense for that lawsuit, that you should have gotten it, but you didn't.
She told me that.
I know, but what's her job as a mediator? What's her job? Scare you, get him to settle.
You have to decide whether the attorney's fees will be greater than just paying off the tenant.
No, I made a good.
Hire a-
It has been 5,000, I've been 500, so.
Oh, I think you did a
Paid
great
500,
job.
you did fine.
Yeah.
Next.
The Section 8 requirement, does that also hold true for single-family residentials that are rented?
The Section 8 requirement goes for any residence, period. And that's a new state law. Crazy. It just came October 1st. In fact, I know a lot about this law because as I was walking out of the office today to do this seminar, one of my associates says, can you believe what they did? And I'm like looking at this as I'm walking out the door and said, oh my God, they did this? So that's my knowledge of the law, but you do have to comply with it. And it's as of October 1st, up and down the state, Section 8 tenants. And if anybody's had Section 8 tenants, just tell me how the place looked after the Section 8 tenant left versus a non-Section 8 tenant. And tell me how the condition of the premises look, because I've done this survey with many people, and it's...
Use that AOA, ABCD qualification.
Hi, Dennis. You're great. We love you so much. But there's about the Glendale. In your presentation, you said only applies to jurisdiction that does not have rent control, blah, 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 and Glendale was one of them. And in my previous question, you said Glendale is exempt. Then you said it's not. Which one it is?
I think you misunderstood me. Again, what I'm saying is since Glendale has its own rent control, it is not affected by the state law. You just have to comply with whatever Glendale ordinance states.
But on your slide, it says on your slide, it says AB 1482, Glendale should comply with 1482. So
I have to see what you're referring to that.
This is your slide. So it's not a trick question. We love you.
It says that they do not have rent control. Only applies to those that do not have rent control. Example, those are places that have rent control. I think you're just looking at it incorrectly.
I see.
Okay.
And one last question. Can you, on the Section 8, can you put a criteria on the income, even though the state is coming up with this deficiency of that? Can you say 3 times the rent or 2 times the rent? That's what my criterias are. Thank you, sir.
Yeah, I mean, you're allowed to set your own criteria for how much rent, but again, you can't. The source of income has to be that if you know that you're going to be getting X amount of dollars from the Section 8 versus the $212 that the tenant's going to pay you, then that's what your criteria is. But again, as Dan says, there is a way. If you don't want to rent the Section 8, there is a way, and most of the time you'll find that they're not credit worthy.
And should you put those requirements in writing?
I think you should.
So Dennis, if we just purchase the building and raise rents to market, come January 1st, we have to bring back the rents. When can we issue the 8.3%?
Good question, and the answer is, so you just bought a building, so let's say you just raised the rent effective as of September 1st, 2019. Now, January 1st comes, you get hit by Governor Newsom's law, and now you're gonna have to roll it back to an 8.3%. You can now raise the rent come September 1st, 2020.
So I have to go back to the March 2019 rent for that 6 months or 8 months?
It's whatever the rent was on March 1st, March 15th, 2019, plus 8.3%. So right now, you raised it 30%. Well, that's great. Well, now you're going to have to, on January 1st, roll it back to just an 8.3% rent increase. And then come September of 2020, you'll be able to get another potentially 8.3%.
Oh, so I have like 7 months to do 8.3, and then come September, I get another 8.3%.
Again, you've already raised the rent to 20%, so you're not going to get another raise. What you're going to get is a decrease come January 1st.
Thank you.
That CPI, that 8.3%, does that apply to all of the state, or are there certain areas that have a different CPI? Like up in San Francisco, the CPI is going to be much higher than it is in San Diego.
It applies to the specific region where your property is located. So they came out with one for the Los Angeles, Orange County area, and it's 3.3%.
But up north?
I don't know what it is up north.
So everybody needs to check to find out what
Yes.
the CPI is in their
Yes,
area.
just do a Google for the area, and as of April of 2019. Don't put in June risk, because it rolls back to what the difference was as of April.
Hi. In the city of Bellflower, I just raised the annual increase in July. So when it comes to next year, does that affect me?
Did you raise it more than 8.3% in July of the year 2019?
Probably not.
Then you're fine. Then nothing's going to happen come January 1st. But if you had a person in that building where you could have raised it 40%, now would be the time to serve that 60-day notice to quit, so that the people of the Los Angeles Times hate me more.
No, how about if I did calculate it, 8.3, how about if 9.2?
Then you're going to have to lower it to 8.3 come January 1st.
Thank you very much.
Hi, thank you. Couple little
What
questions.
did we
on
tell you?
Partridge. I don't know,
I
but,
told you not to touch the mic.
okay. I didn't touch the pipe, I touched his hand.
Well,
Anyway,
that's godlike. This is Father Time here.
okay, it's too close to me. Do you mind if I step back a little bit? It needs to be close to me. Okay, about the garage, separate parking rental. And I set it up as, you said it was going to be a commercial rental. What happens when the rent control, when they do away with Prop 13? Now do they consider part of my building commercial?
No,
It
it's
will
your
not
building.
affect it.
No, the taxes on your building aren't for specific units, it's for the whole property.
So it's still going to be considered?
It's for the property. You have a tax bill for the property.
Multifamily?
Yes.
Okay. And does that check from the tenant have to come separately from the rent check?
Not
It could
necessarily.
be included as
It
long
can
as
be
they have
included.
that agreement, okay.
I have similar question about parking agreement. My last tenant, in the lease agreement, I put one space for one bedroom, and also I did another rental parking agreement. So was that wrong? Should I put like 0 and then do the rental agreement?
You can do it either way, as long as you're separating the agreement for parking from the residence. It just gives you an advantage under rent control ordinances, that you now have control over the parking.
And there's no limit for that, right? As far
Nope.
Okay.
This is just a question about leases. I'm a real estate agent, and they want us to use the California Association of Realtors lease. Has that been effective? Is that a lease
I think
you
that's a
is
good lease.
okay?
They made some changes to it recently, specifically with, I know, the attorney fee limitation where they limited it to 1,000 because they
Right.
were getting killed on that lease. I think that's a very effective lease. I happen to think that the AOA lease is much more landlord friendly. In fact, I'd go so far as to say that if you're a tenant, you'd have to be out of your mind to sign the AOA lease. It's so in favor of landlords.
Okay, but if you can't do that,
If you
then
can't,
that's a
yeah,
good
you got to
second
follow
choice.
what the house wants you to do.
Okay, all right. Thank you.
Our lease can be downloaded on the internet. So you can download it there and get copies.
Single-family residential, do I have to put in there that the property is not subject to rent control?
Yes, you're going to have to put that phrase in there, and the association will have those forms. But no necessity to do so until July of 2020. But the forms will be updated at the association.
Oh, okay.
Dennis, question for you. I just purchased a building and we have 3 bedrooms and the roommates keep changing. Is there a way we can modify it, the lease, saying you can't change roommates so often? Because I'm getting stuck with every week a new roommate coming in.
Okay, well, there's another law called Costa-Hawkins. And if you've originally rented to, let's say, A, B, and C, and then B moves out and is replaced with D, then C moves out and is replaced with E. So now I got A, D, and E, if everybody's following this story. But then finally, A moves out. So even though you've been taking rent from D and E and maybe now F, you now have the right to raise the rent to market value.
So if one of the original leases are on the lease, I can't raise it to market value?
No.
As long as one of them is still in there, from the
Correct.
original lease?
Now, maybe your lease says that the premises can only be leased to A, B, and C. And if they do bring in D, even if they swap it and they didn't get your permission, that would be grounds for evicting everybody. So you have some play there.
Okay, and one last question. If I want to evict a tenant for me to own or occupy it, do I have to go to the newest tenant that was in there or any unit in there?
Okay, again, where is your building located?
Silver Lake.
But it's not under rent control now?
No, built in 1988.
I didn't see any limitation in the law as to which unit to pick. So you can pick any, I know in Los Angeles, they have the last in, first out rule.
Correct.
Which if I want to move in a family member, it's the last guy who moved into a one-bedroom, I got to take him. So even though I got somebody for $642 and the guy's there for $1,800, I got to pick the $1,800 guy because he moved in last. But I did not see that limitation in the state law.
Thank you.
New tenant, new market rent, and how soon can you raise the rent in the next year? No
Well-
rent control.
No rent control? So is it like a house?
No, it's an apartment.
Okay, and what
Where's it
city?
located?
Pardon?
What city?
Monrovia.
Okay, so it's going to be under rent control unless the property was built after 2004. Was it built after 2004?
No.
Okay, so you're only going to be able to raise, once the new law comes, you're only going to be able to raise it once per year, a maximum of 5% plus whatever the CPI is.
Only 5%?
5% plus whatever the CPI is.
Okay, thank you.
Welcome to the world of the leftists.
There's one thing, this 5%, some of you are thinking, oh, I've never raised my rent that much anyway. Folks, it's going to go down. And that's what happened in LA. They started off with 7%. Up in San Francisco, they start off with much higher, and then they just squeeze it on down. So don't sit back and say, well, I'm okay.
Apologize if you covered this, but
Comes forward.
marijuana. I have a non-smoking building. It says no smoking, but I don't break it down to cigarettes and marijuana.
Right.
Is it okay to stay no marijuana in the unit?
Yes, absolutely.
Smoking is
no
the same.
smoking is smoking, you know.
E-cigarette is covered by no smoking.
Of course.
Can we evict for smoking marijuana?
If you have a rental agreement that says no smoking and they're smoking, then technically that would be grounds. Now, they could get what they call a marijuana license, which says that they have a need to smoke it. But next.
So right now, January 1st, you can raise the rent 8.3% based on April to April CPI, right? When does that change? Because the CPI doesn't come out until June. So does
CPI
that
comes
make-
out in many months. I think it comes out every 3 months. And I
No,
know-
but what I'm saying is, you don't know what the April to April is going to be until June.
Right now, we do know what April 2019
Talking about
is.
next year.
Well, when it is next year, right now, if you're going to raise the rent in February, which is before April of 2020,
Right.
it's going to just be that 8.3%.
What if you're gonna
But
raise
if you
the
raise
rate?
it after April, then you're allowed to pick whatever the CPI increase is, or you'll have to pick whatever the CPI increase is for April of 2020.
I understand that. So in May, if I want to raise the rent, I don't know what the CPI increase is going to be, because it's not published, because I know, because I do this for commercial properties. In commercial leases, they
It's
always
when you
put
serve
it's
the
2
3
months
It's when you
before.
serve the 3-day notice.
I'm not talking about a 3-day notice.
I mean, excuse me, it's when you serve the rent increase notice. When you serve the rent increase notice, whatever that is. So you're right, you're not going to know what it is in
Exactly.
April of the year 2020 if I'm serving it in March of 2020.
Right.
But you will still.
Or in May.
But it's when you serve the notice, what the applicable increase is when you serve the notice.
So I'm still
Even if it
going by
becomes-
the previous one.
That is correct. Because there's
Okay,
no other way to do
until-
it.
That's what I'm saying, until the
Yeah,
next
you
one
know,
comes
these
out.
politicians write the law, but they don't necessarily think of all the facts.
No, I know, they didn't think about that.
Of course
That you
not.
don't
Why
know
should
what
they?
that increase is until 2 months later.
Right, that's why it's got to be that you're going to serve the increase as of what it is for that period when I serve the increase.
Okay.
Hello, it's going back to the parking issue. I have a tenant that I've never signed, the parking's always been included. Now, you were talking about the parking agreement, so if he signs a brand-new parking agreement, once that's signed, like either yours or AOA's, then it's completely separate, or do I have to include a 30-day change of terms in addition to, or not necessary?
Are we talking about City of Los Angeles
Yes,
rent
City of
control?
Los Angeles,
You're
yes.
stuck. You gave it to him with the parking, it's always.
No, but it's not under rent control. My building is not under rent control as of now, but as of January 1st, it will be. Could I do a separate agreement now?
And the answer to that is, I don't think so. I think, and this is, again, it would be up to the interpretation of the courts, but I'm going to think that they're going to say that that's an improper rent increase by trying to make it separate.
But you just said you could do.
Right, but you still, for example, and you're the City of Los Angeles under rent control, even though I'm not raising your rent, I'm not allowed to take away your parking spot if it was included in the tenancy.
Even though it's not under rent control? The building's not under rent
You can now, but I think, and this is just a thought, I don't know what the courts are going to do with this. I think they're going to interpret that your tenancy came with the parking spot. So you're basically trying to get around an improper rent increase by deducting services. So I think.
Because I had a tenant sign it, and I clearly wrote
You
zero amount. But
right.
are you allowed to put a zero amount or not?
Of course you can, and I don't know what the courts will do with that.
So you're saying that the City of LA could change it later on and say, well, even though he signed.
Well, this will have nothing to do with the City of LA because your property will only be subject to the state because it's exempt from the city. So your property will only be under the state law.
So you're saying that the state then will say, no, it's not legal.
Well, the state's not going to say anything, but you're going to get into court, and then they might interpret that as an improper rent increase because you decreased services.
Okay. But then when does this parking situation that you mentioned on your screen then, where would that fit in?
When a new tenant moves in January.
So
For new tenants, not existing tenants.
Oh, so you can't.
I say when you lease out a property, rent out the RRS separately, not for existing tenants. I think there's a problem doing it. I think it's a dicey thing, and it might be interpreted that way, but they always interpret things against landlords, so.
But it doesn't hurt to let me see if they'll sign it anyways. I had one sign it, I'm waiting for another one to sign it. So if it works, it works.
If they sign it, I think you're okay, but again, it could be challenged on the
It could be
basis.
challenged later if I decide to raise them $100 and then they come back to me and say,
Say,
oh,
wait a second, that was part of my original tenancy, and this was just a guise to illegally increase rent. And then they'll probably say, you probably went to that Dennis Block lecture.
Okay, all right, thank you.
You couldn't claim, if you were representing him in court after he did this, would you claim this was a new tenancy, therefore it's legal? If you were arguing that side, you argue both sides now, remember?
You might try to do that, of course. But again, I think it would be interpreted against the landlord.
Will RV parks be subject to rent control now?
That's an interesting question. I didn't see anything in the statute talking about recreational parks, so.
Again, single-family residential, lease for 3 years. At the end of the 3 years in the lease, it automatically converts to a month-to-month. Does that still allow me to raise the rent on a single-family residential?
Yes, there are no limitations for rent increases for a single-family residence that's under a month-to-month concept. Two more, and then we're out of here.
Even if I have a, oh no, okay, even if I have a single family and a multifamily unit, the single family is separate, I could do what I want with it, or are they gonna consider it all lumped together?
Are they on the same property?
No.
Okay, no, your single-family
Okay,
is.
here's my real question. Is this thing ever gonna go?
That wasn't a real
That
question, the
wasn't a real
first one?
question. That was up to add
Didn't
on
you
to
think it was
this.
a real question?
Nope.
Oh.
When is this thing ever gonna go to the Supreme Court in California like in New York?
I don't think it's going to, if it goes, it'll be upheld. It's just too much
Why
against.
can't we do anything? Why can't people get together and try it?
We will. We'll wait and see what happens to the New York case. If they win in New York, then we know we'd have a good chance here. Some of you are not going to like me to say this, but if the Donald gets another appointment to the Supreme Court, okay, then it's time to go. It's time to go to the Supreme Court for a decision to get rid of rent control.
I want to have another person on the Supreme Court.
Well, you get a lot of time.
If he gets it, we'll get rid of. We have a good chance of getting rid of the rent control.
Is there a form that you suggest we use to decrease our rent increases that we gave? Is there like a HOA form?
No, you just send them a letter saying under the new state law, I gave you a 25% rent increase. As of January 1st, it will now be less than 2. Just do a note.
Perfect.
Ladies and gentlemen, thank you so much for coming.
Thank you so much for being here. And Dennis, we want to thank you for being here today, and those who are watching on the internet. We thank you for tuning in. And if you have any more questions, feel free to call Dennis's office. Feel free to call our advisors at the AOA office. It's 827-4262. Also, if you're thinking of selling, you've got 3 brokers there in the back of the room. Chuck is there, Charles is there. Feel free to talk to them about the value of your building if you'd like to get an evaluation. Thank you all very much.
What's